Well, to unpack some of the legal jargon then in this murder case is law expert Dr. Llewelyn Curlewis. Good evening to you and thank you so much for your time. A pre-sentence report, what is it and what goes into it?
Thank you and good evening. First of all, remember we have a situation where the accused was convicted in March, more or less this year. So, in other words, what happens is once the accused is convicted, the sentencing phase of proceedings kicks off. Obviously, once the state proved or did not prove previous convictions, then it's up to the defense, first of all, to place mitigating factors before a court in order to get the most lenient sentence possible for their client. Only after that have been finalized, is it the state's prerogative then to provide evidence in aggravation of sentence. So this is standard procedure. There's nothing strange about the proceedings up to now. You must remember that obviously it's not ideal for a matter to be dragging on. But with all due respect, to come to the conclusion of the matter, in other words, to get to the stage where the conviction followed, took numerous months. To now suggest that it's all it's a waste of time or unnecessary further delay in an auspice of more or less 1 month or 2 months prior, just immediately after conviction, is unfair towards the accused. Remember, the sentence phase is probably the most difficult part of the proceedings in a criminal trial, because ultimately the real possibility exists that the accused might be facing lifetime imprisonment. And obviously the defense must get every and all opportunity to try and persuade the court that there are maybe mitigating factors to deviate from that prescribed sentence that would otherwise be applicable in this instance.
Let's talk a little bit about how the sentencing proceedings then will go ahead, because today the court was told that Shoba has elected to have his own private probation officer who will be representing him in this matter.
Once again, that is also nothing strange or nothing new in our criminal law system. Yes, it was possible for the defense to elect that a state-appointed probation officer getting paid by the state appointed to do the probation on behalf of him for the court. But he elected, as anybody else can do, obviously, to get a private probation officer to put his version and mitigation before the court. Any party is at liberty to decide whether to make use of the state-provided and state-paid practitioners or probation officers. Alternatively, they can elect to use their own private probation officers, in which event, obviously, they must pay out of their own pocket for that expertise to be placed before court.
In, the sentencing proceedings in mitigation and aggravation of sentence, the judge is going to hear two sides of the story. There's going to be the pain, the anguish of a family that wants the harshest sentence possible. And, of course, the convicted individual in this case, Ntuthuko Shoba, will be trying to get as little in as far as the punishment is concerned as possible as well. How does the court make a decision around what sentence to hand down? Let's begin first with what is prescribed under his conviction and how much further the judge can take it.
Well, first of all, in typical cases like this, life imprisonment is not an unrealistic sentence to be imposed and handed down. Remember that the minimum sentence legislation is applicable in instances where a person has been committed or convicted rather of murder, like in this instance. So that will be the starting point of the sentencing as far as the judge is concerned. But obviously there are predominantly three aspects that must be taken into consideration when sentencing is imposed: the interest of the community, the seriousness of the offense, and then the personal circumstances of the accused. Those three must be in equilibrium to get to a just and a balanced conclusion for the court. And obviously, in the instance where the defense elect to call a probation officer and maybe even other witnesses or experts to testify in mitigation, they will predominantly focus on the personal circumstances of the accused and rather leave it for the state to concentrate on those other two arms of sentencing, so to speak. to be placed before court.
Dr. Llewelyn Curlewis, let me thank you for your time tonight on this issue.